Distinctiveness in the instant matter is that the High Court has rendered a decision on the validity of the will. Equally notable is the very fact that the appellant process in the succession course has not been exhausted. In Kajiado High Court, in the case of Sugawara versus Republic Miscellaneous Criminal Application number E061 of 2023, Justice Mutuku was confronted with a similar conundrum. In allowing the continuation of the criminal proceedings, she held, and I quote, guided by the provision of Section 193A of the Criminal Procedure Code and the above authority, and taking into account the fact that the applicant has not demonstrated that she will suffer prejudice or that her constitutional rights will be contravened, it is my finding that the applicant has failed to persuade this court to grant the order she is seeking. It is my considered view that there is no prejudice that will befall the applicant as a result of the continuation of the criminal proceedings. End of quote. I've also cited the case of Republic vs. Karisa Chengo and others. That's a Supreme Court decision, petition number 5 of 2015. Be that as it may, Mr. Wandugi Learning Council has submitted that the complainant victim was not consulted before the application was instituted. Justice Muteti, in the case I cited, Pansiba Limited, initiated that courts ought not to ignore the plight of the victim in the exercise of discretion under Section 87A, as doing so will be improper, irregular, and incorrect in law. There has been incipient jurisprudence from the superior courts on how the ODPP ought to exercise its powers to review its decision to charge. In the case of Pansiba Limited case, won by Justice Muteti, the court went further to hold, and I quote, open quote, the learned honorable magistrate should have noted that Section 21A of the Victim Protection Act gives the right to victims to submit information to the police or prosecution on decision on whether or not to lay a charge or to appeal or to withdraw. The request by the applicant for the ruling to be deferred was well within the law and ought to have been granted, and allow the parties to return at a later date to inform the court of any developments before the court could decide on whether or not to allow the withdrawal. The section, in essence, imposes a duty upon the law enforcement authorities, that includes the police and the prosecution, to seek information from victims of crime before the decision to withdraw a matter is made. Similarly, where victims, such as happened in this case, gets to know of the intention to withdraw a matter, he is at liberty to submit information to the DPP, who under Article 10, Article 47, Article 157(11) of the Constitution is obliged to consider the information supplied, make a decision on it, and inform the victim of the decision made. The DPP is not, by doing so, subjugating his authority to control the prosecution, to control the prosecutions to the victim, but simply acting within the constitutional bounds of procedural fairness in decision making and reasonableness. I've also cited the case of Associated Provision Pictures Houses Limited versus Wensbury Corporation, that is 1948, 1 King's Bench 223 at page 223. In the present case, this is the second time the DPP has sought to withdraw or discontinue the charges against the accused person. That is indubitable. I hold that to avoid such awkward situation where the DPP speaks from both sides of the mouth, now we have, in the sense that now we have a case, now we don't, or where the office is accused of arbitrarily and whimsically withdrawing charges against the accused person, the DPP ought to systematically consult the investigation officer and or the victims before arriving at that decision, and also in tandem with the guidelines of the decision to charge 2019. I've cited the case of Frederick Muller, I cited herein above. Therefore, having established that the victim complainant was not consulted, and pertinently that the civil succession proceeding does not bar the continuance of this proceeding, it is the finding of this court that I'll direct the accused person to take plea in the meantime as they pursue the issue of inculcating the views of the complainant or victim and the investigation officer. So the finding of the court is that the accused person will take plea as they explore the issue of inculcating the views of the complainant and the victim.
the typed decision and proceedings certified. We would like to study the same and take further instructions from our clients.
Mr. Somo, that should not worry you. The same will be uploaded shortly after I leave this place.
We get it. We get it. The second application is we would like an opportunity to interrogate the decision together with our client.
No.
If the court will be kind enough to refer for 1 week for us to study it and take directions on our next course of action.
That's it. Yes.
Our client will be making a similar application with regards to supply of the proceedings, certified copy. We were ready to plea taking directed by the court, but we will not oppose the application to defer plea taking.
Yes, Mr.
Your Honor, for the victim, we wish to just urge the court to continue as the court has directed with the plea taking. Doing that, Your Honor, will not prevent the accused person from taking all those further actions that they propose to take in the future.
Maybe you wish to respond?
Well, it is settled law that the persons who brought the mandate to prosecute a matter is ODPP. The participation of a victim under the Victim Protection Act is very limited. Actually, the Victim Protection Act provides that before somebody is even admitted as a victim, the court has to interrogate. That has not been done. So strictly speaking, we don't even have a victim under the meaning of the Victim Protection Act. So the sole party that is prosecuting this matter is the DPP, who has conceded to our application to have the plea deferred. It would be most unfair to have our client being prosecuted for multiple fronts. The sole prosecutors are the DPP who concedes. The complainant has no role in determining as and when an accused person takes plea. We kindly plead with this court